Let's say somebody loses their job. What should parents do if they cannot afford their current payment? Can someone lose their driver's license for unpaid child support? And help me, tell our viewers, tell our listeners, what happens if paternity has not been established?
Then the first thing you would need to do is establish paternity. If both sides don't agree, the court will order a DNA test.
Welcome back to Law Unpacked. I'm your host, Attorney Sean, and today we're talking about child support, a topic that's crucial for ensuring the well-being of children during and after family law disputes. In this episode, we'll cover everything from how child support is calculated to what happens when payments aren't made. Please help me welcome back Joshua Tyson, a seasoned family law attorney here at the DeVries Law Firm.
Thanks, Sean.
Let's dive right in. Josh, what is child support and why is it important?
Child support is a payment that is made from one parent to the other, and it makes sure that the child is having the same standard of living no matter which parent they are spending time with.
Josh, tell me, how does Florida calculate child support?
So, for child support calculations, we take the income of each party, add it together, and then we also take the amount of overnights each party has, and we put it into the child support calculation software program, and it shoots a number out at us. There are adjustments for childcare and healthcare, but other than that, it's the party's income and the amount of time each one has with the child.
Are there any other expenses that are included in child support?
Healthcare and daycare, those are the main two. Is the daycare expenses of the child and the health insurance. The health care is generally not included, only the insurance.
Got it. How does shared custody affect child support calculations?
So it doesn't really have much of an impact on the calculations because they're going to, again, take the number of overnights each parent has with the child, and that's what's figured in for the child support calculation. Whether it's shared or sole custody doesn't have much of an impact unless that sole custody includes 0 overnights. And then the court may ask for a slight deviation if you're under 20% of overnights for the year.
Can parents agree on child support without involving the court?
Unfortunately, no. Child support is a right of the child. They can agree on what their incomes are, which would make child support a specific number. But agreeing that it's going to be an actual number is not something they can do because they would likely be underserving the child. And so the courts would still want to know what their finances are.
What are some of the misconceptions you hear surrounding child support?
So I think we touched on some of these in an earlier episode, but one is that child support cannot be waived. Many people think that they can. And another is that having equal time sharing means that neither party pays child support when that just simply isn't the case. If one is making more than the other, then they will be owing child support.
Great advice. Now let's transition here into filing for child support. Filing for child support can feel overwhelming, especially for those that are single moms or single dads that have the children and they still have a good relationship with the father, the mother of the child. What are the important steps in protecting the child's future?
So, to protect the child's future, you're going to want to have this filing done. I would likely speak with the other side about it first, because either way, you should both want this entered by the court. If you are the spouse that will be receiving funds, you know that money's going to be coming in and you can rely on it. If you are the other spouse, then you'll likely want this entered. Otherwise, they can go back after you for what we call back child support or retroactive child support, which is support that is owed prior to the time of filing. So the sooner you get it in place with the notice that you are up to date, It's best for both sides.
So, can retroactive child support go all the way back to when the baby was born, or is there a specific date that is measured when it comes to retroactive child support?
So for retroactive in the state of Florida, it can go back 2 years.
So, how does someone file for child support in Florida?
You would file a petition to establish child support with the court. You would also, with that, need to file your summons, a UCCJEA, so the court knows it has jurisdiction, and then a notice of related cases, so the court is aware of any other either domestic violence or custody actions with the child.
And you kind of alluded to this, but are there any documents that are required to support a child support claim, like a birth certificate or something of that nature?
You'll need to show that the father is the actual father of the child. That can either be done if he's already been established as the legal father, which can be done through a variety of avenues, such as a parenting affidavit, if consent of the parties, or if it's been established through the Department of Revenue prior.
And so, which we're going to talk about Department of Revenue because I think that's a real important topic here. And I think what you're alluding to is, and help me, tell our viewers, tell our listeners, what happens if paternity has not been established?
Then the first thing you would need to do is establish paternity. If both sides don't agree, the court will order a DNA test or a paternity test to make sure that the father is the actual father of the child. And once that's determined, the court will declare him the legal father, and at that point, he would be responsible for child support.
Are there any fees for filing a child support case?
There are. It's $301. That can be waived if you are have an indigency waiver. But yes, there is a fee for that, and then you would also need to pay for the service of process.
No, it sounded like we were talking about unmarried parents. Can you, if a couple is married, can you just file for child support without filing for divorce?
You can indeed. That is something that we go over with people who are looking to split but are not ready to file for the divorce. I do, however, caution people that when you file for the child support, we often see the other side just go ahead and file the divorce. But it certainly is an option that people have.
How long does it typically take to get a child support order from the time of filing until the order is established?
So, generally, you have to go through your 45-day window to get financials done. After that, it's as soon as you can get in before the court. And we generally try to set that prior to that 45-day window being up. That way, once it has run, we're in almost immediately after.
I want to segment into talking about the Department of Revenue. It seems that in many cases in Florida, it's not either parent that's starting the child support action, it's actually the Department of Revenue. How do they have the authority to initiate a child support case?
So, the Department of Revenue files an administrative case, which can only be done for support. And the reason they have the authority to do so is because the state wants the parents paying child support and then deduct whatever child support payments are made before any state benefits are paid out.
And so, would the state also establish paternity in that aspect, or give us a little bit more information about how they? You've mentioned how they have the authority to initiate child support, but you know, I anybody could just say that they're not the parent. Is that not accurate?
That's correct. Anyone could, but the Department of Revenue does have the ability to have DNA tests ordered to determine parentage. The Department of Revenue does not have the authority to grant any unconsented to time sharing.
So the Department of Revenue's case solely is based on child support, not on time sharing or how that will be affected.
Correct, and that often will lead to a separate child custody case being filed with the circuit court.
So let's assume that we've got our orders now, both from whether it's from the Department of Revenue or from a child support case that was filed by the mother. Unfortunately, not all parents comply with these support orders. Let's discuss what happens when payments are not made. What happens if child support payments are not made?
So if the child support payment's not made, if an income withholding order hasn't already been put in place, one will be at that time. If it's not, the courts will generally give you one chance to make it right. If you don't do so after that, they're going to suspend your license, and then will get more increased in intensity up to incarceration moving forward.
So, how do they enforce child support? Let's start there.
The state keeps track of it through what they call a depository. All the money should be going through the depository. They track that all of the payments have been made. If they're not made, you would file contempt with the court. If the Department of Revenue is running your case, they would file contempt on your behalf, and the court would order it from there. And again, it would be those penalties, um, that quickly get to a suspension of your license, to incarceration. And if you don't want to pay, then you will likely continue being incarcerated for up to 60 days at a time.
And is that's actually commonly done here? Is that accurate, or is that the uncommon case?
It's relatively uncommon. People will generally try to get the money. If you are just willfully disregarding the court's order, you'll likely see some time in jail, and that generally gets the trick done to get people to start making payments.
Let's move on to talking about driver's licenses. Can someone lose their driver's license for unpaid child support?
Certainly, I think as we talked about earlier, that is one of the earlier steps that the courts go to in a child support case. They generally know that people need driver's licenses for a lot of things, mainly to get back and forth to work. So losing the driver's license can really affect someone's income potential, and it's a great deterrent to disregarding the court in terms of child support.
Are there any scenarios where you could get your driver's license reinstated if you've missed payments?
Certainly, you can file with the court, ask for a hardship to have it for specific purposes, such as just for going to work, or have it reinstated and have what are called arrears payments go into place. With that, you would pay your ongoing child support and you would make the arrearage payment monthly in a smaller amount. That money would go towards the back child support that you owe. So if you owed $1,000 and you could pay an extra 50 a month on what you owe every month, then that the $50 arrearage payment would go towards your 1,000 of back payment until that is paid off.
So let's assume one parent lives out of state, and let's hypothetically say I live in New York. Is the Florida courts able to suspend my New York license based on non-payment of child support?
They should ask the New York court to do that under what we call full faith and credit.
Can you explain that just a little bit more for us?
Sure, every court should enforce the orders of the courts of another state. We would ask them to. And so Florida would ask the state of New York to suspend your driver's license.
And what about internationally?
Yes, absolutely. We have the Hague Act, which assists with a lot of these family law matters, as far as giving jurisdiction to the court to enforce all of these international orders. So you can certainly be tracked down. A driver's license would likely be a tough thing to do, but they can still find you and attempt to garnish wages for child support purposes internationally.
So we've talked about the collection of child support. One last thing I want to ask with regards to missing payments and arrearages, how long are those valid for?
They are valid forever. If you owe um, back child support, that is not a debt that's ever going away. There are people that we still have that are paying their back child support when their children are in their 40s and 50s.
Wow. So you're telling me that pretty much child support orders are with you until you die or you pay them.
That's right. Till you die or till you pay them.
So let's move on to adjustments because as we know, life isn't perfect. Things happen. You get new jobs. You have different changes in circumstances. Talk about how to navigate modifications. When can child orders be not modified?
So you'll need a change in the financial circumstances of either party to modify, and that change should be either 15%, a 15% change in the child support, or a change of $50 or more in the child support per month. And you'll likely see that in one party, like I said, losing their job or a significant raise by either party.
Is there an easy calculator out there for somebody to go and use to see if their child support would raise given any circumstance?
There are calculators online. We commonly use the DPA system, which is used by the court. However, there are some free online calculators, but I can't really speak to their accuracy, so because that's just not what we use.
How does the court decide whether to approve a modification request? And is that approval then going to be retroactive?
So the approval would be retroactive to the date that you filed, not to the date of the change in your circumstances. So it's important to, once you have a change in circumstances, you'll want to file as quickly as possible. As far as what they would need to modify, it would be a change of, again, either the $50 or the 15%, and it can't be a voluntary deduction. So if you say quit your job, your child support would not modify, and that's specifically in there to stop um, either parents that are paying quitting their job, being intentionally underemployed, or moving to get a job under the table where they're not showing income on paper.
I know we've talked about this in other episodes, but is there any scenario where child support can be modified without going to court?
No, is the simple answer. You would need to go to court and have the court enter an order. That way, it can be enforced later on.
What is, if let's say somebody loses their job, what should parents do if they cannot afford their current payment?
File as soon as possible. You would want to file to modify. You cannot be held in contempt, or the contempt hearing cannot be held until after your modification has been heard. They can be heard simultaneously, but if you truly lost your job, say it's layoffs, or you were fired not intentionally, the court will not hold you in willful contempt, and they will modify the child support to your current amount, likely, as we discussed earlier, imputing you at minimum wage.
Let's again, we're talking about whether or not when people move on because that's what happens. Changes in life happen. How does remarriage affect child support, or does it at all?
There's no real change because the new spouse's um, income is not factored into that.
So, assuming a parent decides they've had this substantial change in circumstance, and or the $50 a month is going to change in child support, uh, what steps should they take to prepare for a modification hearing?
Preparing for a modification hearing, you'll want to get any documentation of your banking records showing what money you have coming in every month. Your bank records generally will show any deposits that you've placed in there. You'll want to discuss with the court how you are making ends meet currently, whether that be borrowing money or using credit cards, things of that nature. Because what you don't want is saying, I have zero money coming in. You're then opening yourself up to a custody modification if the other parent's going to say, well, you don't have money. How are you feeding the children? So you'll want to have a lot of that information ready to go, showing how you're currently paying your bills, but that you don't have the same money coming in that you previously did.
What advice do you have for parents navigating child support issues?
The best advice I can give is making sure your financial affidavits are all accurate. I believe we discussed it in an earlier episode. A lot of times you'll see people that are underrepresenting their income or expenses, and it just negatively affects your cases. Outside of that, um, try to be understanding with the other parent while this is going in place. If the two of you are both proceeding without attorneys, neither of you really knows what the number should be until the court tells you. So don't go off of you know they need this, you need this amount, because again, this is a right for the child. It's not for the parents.
Well, Josh, thank you for your insight today. That's it for today's discussion on child support. Whether you're seeking support or fulfilling your obligations, understanding the system is key to avoiding conflicts and ensuring your child's needs are met. In our next episode, we'll delve into restraining orders and how they can provide safety and protection during family law cases. Thanks for tuning in to Law Unpacked. I'm Attorney Sean. Take care.